find out how they changed this because they so small.
As long as they can hear it, it's fine. Have a seat, folks, relax.
Like that.
Okay. I was waiting for you to sign.
My directions.
All right, so, record is Charles Kratovil, Kratovil, versus the City of New Brunswick, and Anthony Caputo, Caputo, this is docket number L 3896-23. We have a lot of people, I guess we'll start with your appearances.
Good afternoon, Your Honor. Alexander Shalom from the American Civil Liberties Union of New Jersey Foundation on behalf of Mr. Kratovil, who's present to my left.
Okay.
Good afternoon, Your Honor. My name is Susan O'Connor. I'm from Hopeland, Longer, Moran, Dunstan, Dukas. I represent the defendant, City of New Brunswick, and Director Caputo.
Okay, and I know everybody else is on Zoom. Let's go one by one as to who's here.
Good morning, Your Honor. Paul L. Kleinbaum, on behalf of the amicus curiae New Jersey State DBA, and with me on this meeting is Sheila Morrigan from our office.
Okay. Who's next?
Good morning, Your Honor. David Disler, Porzio, Bromberg, and Newman, on behalf of the New Jersey State Association of Chiefs of Police.
Good afternoon, Your Honor. I'm Robert Cannon, Markman and Cannon. I represent the State Troopers Fraternal Association of New Jersey, the STFA.
Your Honor, good afternoon. Joe Paravecchia. I'm from the Hunterdon County Prosecutor's Office. I'm here on behalf of the County Prosecutors Association of New Jersey as amicus curiae.
Okay. And I think we got one more.
Yes, Your Honor. Good afternoon. Richard De Fortuna from Markowitz and Richmond on behalf of the New Jersey Fraternal Order of Police.
Okay. And
good afternoon, Your Honor. Deputy Attorney General Nicole Adams on behalf of the Office of the Attorney General.
okay, I was wondering if you were going to show. Okay. All right. So last week, 23rd, you all were here. Well, Miss Adams wasn't here. Everybody else was here, and the issue was this case started as an order to show cause with a verified complaint for relief from Daniels law to permit the plaintiff, who was a reporter, to report in an article the address of Anthony Caputo, who is the current director of police in New Brunswick, and that obviously is strongly opposed. Ms. O'Connor represents New Brunswick and Director Caputo, and all his other attorneys who are here representing various amicus parties, police organizations. So last week, what came up was whether or not, and nobody really knew the answer, apparently there was some discussion between certain of the lawyers and a representative from the Attorney General's office, whether or not the Attorney General was planning on intervening. Everybody was cognizant of Rule 428-4D about the 60-day period during which that decision could be made. But what I really wanted to accomplish was to get something definitive from the Attorney General's office as to whether or not, whether you know or whether a decision has been made, whether that office or whether the Attorney General's office intends to intervene in this matter. So, Ms. Adams, what say you?
Your Honor, at this juncture, I do not have an answer as to whether or not we will be intervening. As we represented in our letter under the court rule, our calculation is that we have to let Your Honor know by September 12th as to whether or not if the Attorney General will be intervening into this matter.
I'm not so sure about that date. Is the operative date the 17th or 18th?
Your Honor, I believe the operative date is July 12th, which is the date on which I served notice on the Office of the Attorney General.
You did?
I did.
Oh, okay. Then hold on a second. Then, make sure we're all on the same page. Because there's 31 days in July, so that would be the 11th. I think you have to, well, the 10th of September is a Sunday. I think you have to September 11th.
Makes sense, Your Honor.
Do you all agree?
That's fine, Judge.
I use a computer program to try and figure this stuff out because I have such a hard time doing it, so I have no reason to doubt your calculation.
I'm just saying, there's 31 days until I know it.
It logically makes a lot of sense. That it would be one less than the, yes, I agree.
Okay, so you have to September the 11th. All right, so I just want, all right, so I have that. I have letters came in last couple of days. The first from Mr. Shalom, dated, I believe, the 28th. I just want to acknowledge everything that came in. Okay. And basically, Mr. Shalom, you're taking the position, you know, this came to the court via an order to show cause, and that the delay is unacceptable, and you wish to push forward with this matter.
That's right, Judge. In essence, though, we acknowledge what the Attorney General has said and have acknowledged that the whole time, that we're only here today seeking temporary restraints. We would like to set a date today at which we could come back on permanent restraints. It would have to be after the 11th. I'm happy to talk about scheduling on that, but we asked for temporary restraints. And let me step back for one moment. We asked for temporary restraints in our papers, and the presiding judge assigned the case to Judge Rivas, and it was scheduled before him on the 11th of August. And everyone was prepared to appear on the 11th to argue the merits of the case. Judge Rivas delayed that date twice to the 23rd, and when we showed up on the 23rd, first of all, asked whether I provided notice to the Attorney General. Once he confirmed that I did, he let us know for the first time that he was encumbered by a conflict, and therefore he couldn't handle the case. We were frustrated by the timing of that, asked why it had taken 36 days of him knowing about a conflict for him to disclose it, knowing that we alleged an emergency and that we wanted immediate relief on behalf of Mr. Kratovil. And Judge Rivas said, well, it wasn't an emergency. I explained to Judge Rivas that that was a substantive determination, that if he was encumbered by a conflict he was not entitled to make. And then it was Judge Rivas who for the first time suggested that for 60 days he wouldn't be allowed to do anything in that case. I told Judge Rivas then, as I told you later, that I thought the rule was very clear, that there was a limitation on a final order, but not on an interlocutory order. And so I provide that kind of procedural history for the following reason. Everyone thought they were coming in first on the 11th and then on the 23rd to argue the substance of the case. It wasn't until Judge Rivas, with his conflict, mentioned this alternate theory of deference to the Attorney General, incidentally a theory that the Attorney General themselves eschew. They don't espouse the theory that you have to wait to order temporary restraints.
You don't.
Right?
No.
And so, but now we have the defendants asking us to wait on behalf of the Attorney General, who isn't asking for us to wait. And so, quite simply, we would like to get to the substance of this matter because we believe that the prior restraint that has been imposed against Mr. Kratovil is a First Amendment violation, and he suffers harm every day that it exists.
Okay. All right.
May I respond, Judge?
Well, in a second, I just wanted to acknowledge all the correspondence that came in, and that's basically what Mr. Shalom put on the record is what's in his letter dated August 28th. On the same day, I got a letter from an Adam Marshall from your office, counsel, from the Attorney General's office, pretty much telling me what you just told me, that you're not sure what you're doing. And I also received a letter from Ms. O'Connor. Here's her real letter. Here it is. correct me if I'm wrong, Ms. O'Connor, but in a nutshell, your letter dated August 29th says that proposed temporary restraints are identical to what's sought as a final order.
What's in my letter, Judge, is if Your Honor hears argument on the temporary restraints without the intervention of the Attorney General, and that is in our brief, and it is in the amicus brief. If you hear argument with respect to the temporary restraints, the heart of this matter is the constitutionality of the statute. Director Caputo merely followed the procedures of this statute as a covered person. And when he provided notification, he did it in accordance with the statute. The plaintiff seems to have issues with the statute, so in their reply brief, they specifically provide helpful suggestions about how the statute in their mind could be fixed. And that is not the realm of Director Caputo. We can't fix the statute. That is the realm of the Attorney General. The plaintiff also suggests that this case is emergent from their perspective. If Your Honor grants the temporary restraints, and permits the plaintiff to publish 123 Main Street, the complete address, there is no opportunity for us to have that address redacted at a later date. Daniel's law, as you know, permits persons to provide notification, permits procedure with respect to the publication, republication, posting, or reposting of the addresses. The argument that we made is that the temporary restraints, if they are granted, is in essence a final version. And therefore, the Attorney General should be in this case with respect to the validity of the statute. And if the plaintiff wants to argue regarding the constitutionality of the statute, and which obviously should be liberally construed because of the legislative purpose in creating this statute, that is with respect to the Attorney General. They should be permitted to have the 60 days within which to make their decision.
Nobody's disputing that. The issue is whether and to what extent the interlocutory relief that is sought, in other words, what Mr. Shaw referred to as temporary restraints, is synonymous with the ultimate final relief. In other words, one and the same. Which would mean that there is no interlocutory relief even available to be considered. That's the problem. On the order to show cause, as far as preliminary or temporary restraints, it reads preliminarily enjoining defendants from seeking to impose any criminal or civil penalties upon plaintiff for publication of truthful, lawfully obtained information about defendant Caputo's home address. But that's the ultimate relief that's being sought here. I mean, they're the same thing. And I think the problem with the plaintiff's present position is you can't distinguish between the two. In other words, what's sought via a final judgment is the same thing that is sought via the interlocutory relief. In other words, the temporary restraints. Because they're the same thing, and there's no distinction between them, there is no interlocutory relief that could even be considered. And yes, the rule certainly permits that if there was interlocutory relief that was different from the final judgment that was sought, that yes, that can certainly be considered, notwithstanding the expiration of the 60 days, notwithstanding whether or not the Attorney General's office decided to intervene. But that's not the case here. They're one and the same. They're the same thing. which means, notwithstanding the fact that this is an order to show cause that was signed by Judge Kratovil, well, I think it was signed a couple times, but ultimately, July 18, 2023, I mean, just the mere fact that this order to show cause exists, it's been determined that this is an emergent matter. So to go back and say it's not emergent, I'm not Judge Kratovill's appellate division. I think that is pretty much set. But we're bound by 428-4D. In other words, it's notwithstanding that this came via an order to show cause on an emergent basis, the matter is stalled pursuant to this rule for this 60-day period for the Attorney General to decide whether or not they're going to intervene. And as we, I think, are all in court at this point, that date would be, I'm sorry, what's your last name, counsel, for the Nicole Adams?
Correct, Your Honor.
Okay, so we're all on the same page, September the 11th?
Yes, Your Honor.
All right.
Judge, may I have one more shot at this
Of
question?
course, of course you can, Mr. Sloan.
Thank you. Perhaps a hypothetical explains why that reading would be so troubling. So there's a statute in place, it's 18A 36(3)C.
Wait.
It doesn't much matter, Judge. I'm going to tell you it's unconstitutional in a minute, and it's been decided by another court. But it's 18A:36-3C.
Okay.
And what it says is school districts shall require pupils to stand for the Pledge of Allegiance.
Okay.
And it says everyone should do the Pledge of Allegiance, but if you have conscientious scruples against it, you just have to stand respectfully. That's what the statute says. And in the 1970s, a federal challenge was brought by a conscientious objector to the pledge to that portion, that they shouldn't have to stand for the pledge. And District Judge Meaner agreed, severed that portion of the statute, said that portion is unconstitutional. It went to the Third Circuit in a case called Lip v. Morris, Third Circuit 1978 case, and they agreed that that portion is unconstitutional. The New Jersey legislature in the intervening 45 years has not amended the statute. So we have this unconstitutional statute that remains on the books. And so a couple different times, the State Department of Education has told districts, hey, by the way, you can't enforce this statute, it's clearly unconstitutional. But imagine a situation where today a district said, I've looked at the statute, and I think that little Johnny must stand for the pledge, or he's going to be suspended or even expelled from school. So Johnny comes to court and says, I would like temporary restraints that say I can go to school in the meantime. And then I'd like you, Judge, to declare again that this statute is unconstitutional. So the legal question is settled. But I understand that the Attorney General has 60 days to come in to try and defend this, that they haven't defended before, but they could defend it for 60 days. But in the meantime, I'm entitled to some relief. If the reading propounded by the defendants holds true, then the district gets a 60-day get out of unconstitutionality free card. And that's not what the rule proposes. The rule says you can, so let me say, I don't think the relief that we're talking about is identical. We asked for a preliminary and a permanent injunction preventing them from seeking civil or criminal penalties. We asked for a declaration that the statutes were unconstitutional. That has to wait until September, we agree. A declaration that the cease and desist letter is null and void. That has to wait till September, we agree. An award of attorney's fees, that has to wait, we agree. And other such relief as the court deems just and proper. But I think one interesting thing about the argument we've had thus far is it all assumes that we're gonna win. And I like that assumption. But remember, the court could reach the substance of this issue and yet find that we're unlikely to prevail on the merits. And if that's true, why have we had to wait for 60 days to seek appellate review on an interlocutory basis of the determination that we're unlikely to prevail on the merits? We're now being forced to wait for that on the assumption that we'll win without a guarantee that we'll win. And so let me just say one more thing, because it comes up in the letter from Ms. O'Connor. I proposed last time that if the court, I have actually 2 more points to make, if the court were to rule our way and issue a temporary injunction that says Mr. Kratovil can publish 123 Main Street, use the same shorthand that Ms. O'Connor did, we acknowledge that Your Honor would be empowered to stay that decision pending review by the appellate division. If the appellate division thought that we were not likely to prevail on the merits, or that the equities didn't favor us, they would continue that stay. If they thought that despite the Attorney General's suggestion that they don't need you to wait, that you had to wait, the appellate division could issue a stay. Mr. Kratovil has waited to publish this to hear from the court. Though I don't control what he does, I would be very surprised if Your Honor issued an opinion and stated that Mr. Kratovil would publish at that time, and if so, he would risk the penalties that come should the appellate division reverse. So I simply don't think your hands are tied until September. And I will add one more point on the similarity between the temporary and permanent relief sought. The Attorney General, in thus far declining to intervene, but acknowledging that you have the ability to issue an interlocutory order, has read the request for relief. The Attorney General's office understands the overlap between the temporary restraints and the permanent restraints, and yet hasn't felt compelled to come in. And so this isn't that the Attorney General's office is being duped and tricked into knowing what we're asking for. They know what we're asking for, and they have not yet made a decision one way or the other, as is their right under the rule.
Okay.
Just briefly, Judge, if I may.
Sure,
Thank
go
you
ahead.
very much. Under the request for the order to show cause, it has to be emergent. This is not emergent, and therefore Mr. Shalom's argument or hypothetical is not the same. We are not expelling Mr. Kratovil. In fact, we have indicated in our briefs he can publish whatever article he wants, he just can't use the specific address in accordance with Daniel's law. And irreparable harm, of course, is the other issue, and as I've indicated earlier, the irreparable harm would be to Director Caputo. The fact that the plaintiff is indicating that it is separate and there would be a stay up to the appellate division, it belies the idea of emergent relief. And the last thing I want to indicate is that we are not assuming that the plaintiff's winning. In fact, we obviously are vigorously defending this case, but it is based on the statute, and the heart of this case is the constitutionality of that statute, which is not something within the power of New Brunswick to address. It is within the power of the Attorney General to address, and that's why I
Well, it may
believe
end up being up to you to address.
it may be, but they are entitled to the 60-day window, according to the court rules, to make that decision or that determination as to whether or not they come in, given that the temporary and the final injunctive relief are the same.
I just have one question.
Sure.
Why didn't you move against the order to show cause if you felt it wasn't emergent?
I oppose the motion, Judge, as opposed to filing a cross motion.
Wait, you came in ex parte on order to show cause.
I did not come in ex parte, Judge.
Oh.
I missed
So
the,
this,
He served the order to show, I'm
this
sorry.
was, oh, so your order to show cause verified complaint was served on, was on notice,
it was on notice.
Yes,
and you opposed it?
and I opposed it,
Oh, all right.
as did a number of other people.
All right,
I don't,
all right.
just,
I opposed your motion.
not before the order to show cause was signed on July 18th. I don't even think you were in the case before July 18th. Is that right?
I was not.
Right, so Judge, just, and I was,
To be clear.
right, because I think we're just trying to make sure we're
Yeah.
speaking clear on, I filed on July 12th on notice to Corporation Counsel for the City of New Brunswick. I then refiled on July 17th with a changed verification, again on notice to Corporation Counsel and to the Attorney General both times, pursuant to the to 428.4a. The order to show cause was signed without opposition on the 18th, and Ms. O'Connor filed her timely objection to the relief we sought
Yes.
on, I believe, August 3rd. But so she didn't oppose the emergent nature of it because it had been signed at that point before she had been assigned to the case.
Right, and it had been obviously within 24 hours. I was not in the case at the time, and therefore I did not oppose the order to show cause. I did oppose the relief sought.
But Judge, I might just say, I'm happy to have a discussion about things like irreparable harm and harm to Mr. Kratovil, but that's the substance. That's what I want to do, is talk about that. What I don't want to do is be told, we can't have that discussion except to the extent defendants want to. We have to either fight on the merits or not fight on the merits, in which case we'll, do whatever is appropriate. But those are, I think, the two options we have.
All right. So I see one maybe distinction between the scenario that you gave me about the Pledge of Allegiance. In that matter, I think clearly on an application that child would be entitled to temporary restraint because there was a prior ruling.
And Judge, we think that the precedent in this case is equally clear. We think that the line of cases that says that once the government releases something into the public, they can't prevent a journalist from reporting on it is as clear as the Third Circuit case there. But again, Your Honor can disagree with us and say that we're not likely to prevail on the merits, but that's the substantive ruling that we want. And when the defendants say that Mr. Kratovil isn't harmed, we've alleged a violation of the First Amendment.
No,
and
you don't have to.
and Judge Crisatello accepted.
Right, and I accept that. I accept that. As far as whether or not it's likely to prevail, there's so many ways that he could not prevail on the merits. One of which is constitutional grounds. So to say now definitively whether I think he's likely to prevail or not prevail, I think is premature, because I don't have, assuming I'm getting something from the Attorney General's office, I don't have anything yet. So.
But that's true in every case where someone comes in and says, Judge, I'm alleging a constitutional violation, I'd like you to act on it now. We don't wait 60 days to get their view.
But for a court rule, you're absolutely right. You don't wait 60 days.
No, just to be clear, we do to strike down the law permanently. But courts are empowered under Crow v. de Goya to say here, and one of the questions they have to ask is, are you likely to win? And it doesn't mean that the court is always right. The court might change their mind in between the issuance of temporary restraints and the final restraining order hearing. But we don't forestall that decision because it's complicated. I mean, that's the nature of these emergent motions on orders to show cause.
So the temporary relief you're asking for is to permit Mr. Kratovil to write his article without any civil or criminal repercussions.
That's correct, and we acknowledge that Your Honor could stay that order pending review by the appellate division. That would at least move the case forward, and that would give a fresh opportunity. Depending on the scope of Your Honor's order, the Attorney General might decide to intervene, to not intervene. They might not. The defendants might decide to seek appellate review. They might not. But the idea that the ink is in the milk once Your Honor rules. I mean, our view is that the ink is already in the milk because the address is already public. It was released by the government. It's available on Google. But even if the idea is that it's only the writing by Mr. Kratovil that would release this into the public, I don't understand why a stay wouldn't protect the status quo in the way defendants say any stay to this matter would not cure a grant of interlocutory relief resulting in the publication, but I'm actually not sure why that's true. A stay, the whole point of stays in general is to maintain the status quo. And so the only way that Your Honor's decision would be the final word is if the appellate division says, we think Mr. Kratovil is so likely to succeed on the merits and the equities so favor him that we're gonna lift the stay.
But, okay, you mentioned Crow versus DeJoya, which the same factors would be considered in granting the stay.
That's right.
So on the one hand, I'm saying he's likely to prevail, so I issued the temporary restraint. But on the other hand, I issue a stay indicating that the defense is likely to prevail on appeal.
But this would be with the concession of the plaintiff that a limited stay is appropriate for appellate review. I mean, this happens all the time, that trial judges issue an order and yet stay the order pending appellate review. I mean, the appellate division sometimes stays their orders pending Supreme Court review. It's really nothing more than an act of humility. It's suggesting, I think I've gotten this right, but I concede the possibility that someone will disagree with me and don't want to upset the apple cart in the interstitial period between my decision and review by another court.
With respect to a stay, Judge, look, either way, should you grant temporary relief, which I am not conceding that you should at this time, because, as I said, once, if the plaintiff wins, the address is then out in the public and there is no ability to claw that back. There's no ability to cure that. A stay, going up to the appellate division, there is no relief if the appellate division determines that they do not want to take this on an interlocutory basis. And that is the problem, because the harm that could befall, obviously, not only Director Caputo and his family, is with respect to that information being out in public and potentially people harming law enforcement officers at their residences. That is what Daniel's Law is available to protect.
That's when the interlocutory relief becomes synonymous with the final
relief
judgment.
Yes.
That's
and the ability under
the problem.
And the ability under the rule with respect to the temporary relief and the final relief permits the Attorney General to make their decision. I don't know what their decision is going to be, and Ms. Adams has indicated that it's still pending. At the end of 60 days, which is in 2 weeks, Ms. Adams, I'm assuming, will communicate that decision, and we will go forward from there.
Is it going to be you, Ms. Adams?
Your Honor, it would either be me or a member of my team.
How many people are on that team?
My section has, it would either be, you'd either hear from me or my colleague, Adam Marshall, who wrote the letter.
There's another person that you mentioned.
Mr. Feigenbaum is the state solicitor, but having spoken to Mr. Feigenbaum, I agree with DAG Adams that it would be someone from her team who would be conveying this. I think she's been in touch with Mr. Feigenbaum, but.
Absolutely.
The points that she just made is really the heart of this, Mr. Sloan. I can't separate the interlocutory relief from the final relief. They're really one and the same. And her, which she points out, I think it's intellectually dishonest to grant temporary restraints and at the same time issue a stay. Plus, at that point, there's no guarantee there's going to be any further judicial review on that. And that's a problem.
Judge, might I propose one other thing, which is, as I said, all of this assumes that Your Honor will rule our way. Why don't we argue the merits of it, such that if Your Honor rules our way, then you can say, and I'm going to hold this in abeyance until September 12th or whatever date, but if you rule against us, that at least gives us a chance to seek appellate review sooner rather than later. We already feel like we've waited 6 weeks, longer than we should have on this emergent basis. And all we're asking for now is the chance to argue it. I understand Your Honor might be hesitant to issue temporary restraints even if you think we're likely to prevail on the merits. That's in some ways further on down the road, but right now we're being precluded from even making our case that Mr. Kratovil's rights under Article 1, Paragraph 6 have been abridged.
Yeah, but under that scenario, you're assuming you're gonna lose.
No, I'm not. I very much am not assuming
Yeah.
that, but I'm assuming that I want my chance to make the argument so we know whether we're likely to win or likely to lose. And that, again, you might say that if I win, you're not gonna issue temporary restraints. You're gonna withhold the decision until that date in September.
I can tell you that that I would not give you temporary restraints for the simple reason that it subsumes the final relief. It's the same thing. You may ultimately win, but I want a full record.
Well, so a couple things.
So, in order to proceed without them, inside the 60-day window, would be the understanding that you expect to lose, so that you could then, notwithstanding their right to intervene, go right to the appellate division.
May I ask a question about Your Honor's interest in a full record? What you mean by that is you'd like to hear from the Attorney General if they're going to come in, not that you're expecting to take testimony or hear evidence. I mean, I think we all believe, I'll speak for myself, I believe this case can be decided on the papers. I don't think there's any extra record information I don't think we need to engage in discovery. I think it's here. I think to the extent Your Honor has questions, we can supplement it, but I think on a date in September when Your Honor hears the final restraining order, I think I am prepared to move to argument rather than to the presentation of evidence of some sort. And I think the verified complaint provides a basis for us to do that.
Do you envision testimony in this case?
Not unless Your Honor has specific questions with respect to the testimony, and of course the testimony can be taken in here. I do not envision discovery and depositions like Mr. Shalom has indicated at all. But obviously if Your Honor had questions, Your Honor would be obviously permitted to ask those questions, and the deponent would be, or the individual would be under oath. But other than that, I do not see Mr. Shalom's thought process with respect to the extension. As I've indicated, it is 2 weeks from today with respect to determining whether or not there would be restraint issued in this matter. As I've indicated, and I think Your Honor agrees, any temporary restraint is the same as a final restraint, and for that, the Attorney General should be given their full opportunity to make their decision.
The last thing she said. I mean, look, even the act of choosing not to intervene is somewhat telling.
It is.
Sure.
What you propose is very interesting, and I follow your logic, but I think it's intellectually dishonest. And I think it breaks down. I think I need a full record. I'll be honest with you. I have no problems with this coming forward via an order to show cause, but I'm questioning whether there should have been a request for preliminary relief, given this rule, and rather just show cause why this really shouldn't be granted. The timing would have to be tempered in accordance with this rule. But I think in this particular case and what's being sought, I think preliminary relief is an apposite.
I understand Your Honor's ruling. I would like to schedule the hearing on the final restraining order.
That's the next thing I wanted to talk to you about. Okay, so they have September 11th is the day. Have either of you had experience with the Attorney General on similar issues? Can I expect to hear from them on September the 11th?
I think that question is probably better directed at Ms. Adams.
Well, do you?
Respectfully, Judge, I think you can read whatever you would like into the fact that they haven't yet intervened, and you can read something else into the fact if they do or don't on September 11th, but I don't think they're gonna commit one way or the other because the rule gives them the 60 days. But I have seen cases where they have chosen not to intervene.
Okay.
I've seen cases where they've intervened after an interlocutory stage. I've seen cases where they have not intervened after an
I
interlocutory.
guess my question was, would you expect them to do something, if they were gonna do something, on the last day or very close to it? Or there's a mixed bag?
I haven't had experience with them doing that, but.
All right, so Ms. Adams, you concur with what Mr. Solomon just told me?
Yes, I mean, our office has, depending on the case, intervened in some instances. But if you're asking whether or not I expect that we will advise you one way or the other on or before the 11th, I can't say at this juncture on which day. We just know that the rule requires that we must respond one way or the other by the 60th day.
All right. What do you have in mind?
Judge, I have arguments at the New Jersey Supreme Court on the 11th and on the 12th.
Okay.
And then we're gonna run into a problem, because I am away from the 13th to the 20th, so the first day after your arguments could be the 21st.
I will make it happen on the 11th or the 12th, Judge. I would ask for some forbearance on scheduling such that I can contact the Supreme Court Clerk's office to find out what times those arguments are likely to be scheduled. I have 2 arguments. There are 4 slots. There's the morning of Monday, the afternoon of Monday, the morning of Tuesday, and the afternoon of Tuesday. I will see if I can get a commitment that the afternoon of Tuesday will be clear, and if it is, I will ask for the 12th at 1:30.
And just one more issue, my client will also be on vacation on the 11th and the 12th. The week of the 11th, so if your honor would want testimony, that would be difficult.
All right, let's say Ms. Adams' office decides to intervene and file papers. You want to do this on the same day?
Not the same day, but the following day. I mean, I think if they have till the 11th, I would like to be heard on the 12th.
Tell you what, because in my clerk's just reminded me, I'm also out the 11th and 12th. I'll be back the 13th. Why don't we do this? Are you all around the 15th?
No, Judge, I'm not. I'm away. I'm out of the country, actually. I will be back on the 21st.
When do you
I can argue
leave?
it right on the 21st, if your honor.
When do you leave?
I leave on the 13th.
What time do you leave on the 13th?
Either 4 o'clock or 6 o'clock.
And you're back in town when?
The 21st. I'll be ready to argue it on the 21st. That's when I get off the plane the night before, and I'll argue it the next day.
Judge, I think, so again, the argument that defendants made is, oh, it's only 2 weeks. It's not. We're now talking about fully, sorry for the math, I think 9 weeks after we filed our order to show cause that will be heard by a trial court on the merits of this issue.
We can do it the morning of the 13th.
That would be my preference, Judge.
If your honor is available, we can do it on the morning of the 13th. If not, I'm out of the country until the 21st.
60 days is almost, how many weeks? 8? More than 8. And we're stuck with that. I didn't even mention the rest of the rule. But for now, I'll tell you what. For now, let's list it for, you said you'll be ready to go for the 21st?
She said she could do the 13th in the morning, Judge.
Yeah,
I
but
did say the 21st, Judge.
I'm not gonna be here. I'll be back on the 13th, and I need a chance to read whatever Ms. Adams' office is going to submit. So I give you the 21st. What time?
Whatever time Your Honor wishes, I'll make it happen.
Well, you're landing that day or the night?
No, I'm landing that night, the 20th.
The night before. How about you, Mr. Sloan?
I have a speaking engagement that I was supposed to do in Jersey City at noon, but I'll cancel it. I mean, I want to be heard today, and so the 21st feels eons away, Judge, but I will make myself available at any time.
9 o'clock?
Yes?
9 o'clock is fine, Judge.
All right. Everybody who's on the screen here via Zoom, any conflicts with that scheduling for the 21st at 9 o'clock?
Judge, will you entertain participation via Zoom, or do you want people in the courtroom that day?
If you want to appear via Zoom, we'll do the best we can. That's up to you.
The 21st works for us.
And you are who?
Paul Kleinbaum on behalf of the state DBA.
Okay, who else? And put it this way, anybody have a problem with that? Whether in person or via Zoom?
Not on behalf of the STFA, Your Honor.
All right, so I'll take by your silence that everybody's good. Ms. Adams, that's going to include your office as well. Are you prepared to speak to that at this point?
Understood, Your Honor.
All right.
In the event, if my office intervenes, which I can't represent, and there is argument, a representative from my office will be there.
Okay.
Your Honor?
Yes?
Just one point, since we don't have to avoid any issues moving forward. I don't know if the Attorney General would plan on filing papers on the day that it notifies the court that it would like to intervene. In that event, it doesn't do so. Do we want to set a date for them to file the papers now?
No.
This way everyone has time to read it in advance of the 21st, I think, or
Well, why don't you put
whichever the date
your,
was.
okay, why don't you put your name on the record?
Sorry, Your Honor. This is David Dislow on behalf of the State Chiefs Association.
So the
And
answer, the answer is no.
Okay.
Well, anything else?
Judge, I'd ask for an order setting these dates such that we can consider.
Same as you did last time. Submit one.
You submit one, just send it to me first, is what you said.
Right, and I guess I'm wondering whether the order should come from this proponent. Like, this is not the schedule we want. We wanted the substance. Our request to be heard on substance was denied.
Right.
And so I'm suggesting that perhaps it's the defendants who should put forth the order. I will if Your Honor wants me to, but we don't.
Listen, I have no issue creating the order in accordance with Your Honor's rulings today. I will submit
All right.
it to the plaintiff so
I
that
just
you
thought it
can
might
look
be,
at it before
the
I
wording
submit it.
might be easier
I guess,
from you.
just in candor, I want to talk to my client and my colleagues about the possibility of seeking interlocutory relief of the
Yeah.
order, and so it feels disingenuous to write an order that I'm then gonna appeal. And so,
Really?
I'm happy to do it,
Well,
but
It's fine. I will
I
do it,
would,
Judge.
whichever one of you, but I would,
you'll ultimately be the one to sign it, obviously, so.
right, but as far as the language, as long as you circulated it to her
Okay.
and everybody else.
Yeah, thank you. Okay, thank you.
You want her to.
She said she would, and so I'll
That's fine,
accept her.
that's fine.
Thank you, Judge.
And then, okay, fair enough.
Thank
All
you.
right, so and you're gonna put in that order, well,
I'm-
for now, September 21st, 9 o'clock.
Yes, I am.
All right,
Okay,
what else, anything else?
I have nothing else, Judge.
Thank you, Your Honor.
Thank you. Nice vacation to you both.
Okay, folks, I think we're all set. You can
Thank
go,
you, Judge.
go ahead and sign
Thank you, Your
off.
Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, you're all set, right, Bill?
Offer, yes.
Yeah.
Thank you, Judge.